Start. Pyara. The President, Income Tax Appellate Tribunal, wide order under Section 255 in bracket 3 of the IT Act 1961 dated 7/6/2005 constituted a special bench for hearing all the aforesaid appeals to consider the following question: whether the depreciation which is thought allowable but not claimed in the return for normal computation of income has to be allowed while computing the deduction under Chapter 6 of an industrial undertaking. The facts in all the above referred cases are more or less similar. Therefore, we shall discuss here in detail the facts in the case of Wahid Papers Converters Wide ITA number 1686/2004. The assessee is a partnership firm engaged in the manufacturing of paper. The assessment year under consideration is assessment year 2001-2002. The assessee filed the return of income on 15/10/2001, declaring nil income. It has a manufacturing unit located in the Union Territory of Daman, which is a backward Union Territory, as specified in Schedule 7 of the IT Act. The income delivered from the manufacturing unit is eligible for deduction under Section 80B of the Act. 100% of the income of such manufacturing unit for a period of 5 years and then restricted to 25%. The year under consideration is the 5th year of manufacturing activity. The assessee did not claim depreciation on fixed asset for the year under consideration, though it has claimed the depreciation for the earlier years except for the assistant year 2001-2002. In the opinion of the AO, by not claiming depreciation, it has not foregone its right to claim the depreciation and started claiming depreciation from 6 years on the original cost of the assets. When the deduction is limited to 25% of the eligible deduction income of the assessee, by adopting this modus operandi, he held that the assessee tried to reduce the tax liability from 6 years. This type of modus operandi, if accepted, will be an injustice to the honest taxpayer who are still claiming depreciation and showing true state of affairs as far as their income of industrial undertaking is concerned. The assessee, by not claiming depreciation, is actually planning the tax avoidance leading to tax evasion. It is a type of colorable devices by using dubious method and cannot be accepted in view of the finding given by the Honorable Supreme Court in the case of McDonald's and Company Limited versus Commercial Tax Officer 154, considering the ratio laid by the Supreme Court in the case of Cambe Electric Supply Industrial Company versus CIT 113, and the decision of Honorable Bombay High Court Jurisdictional High Court for the Union Territory of in the case of Indian Rayon Corporation Limited versus CIT 261. The AO recalculated the income of the industrial undertaking eligible for deduction under Section 80B by allowing depreciation for the year under consideration. Para. The CIT observed that the applicability of the provisions of the Act must be the same for same class of the assessees If any benefit is given to some class of the assessee, it should be given to them universally, without any kind of difference. The method of computation of income should be the same for the assessees who are eligible and claiming such deduction, but this is not being followed by certain assessees while computing eligible income of such industrial undertakings. Certain assessees are claiming depreciation to arrive at the total income of the industrial undertaking since inception, but certain assessees are not claiming depreciation in the guess tax planning for arriving at the total income of their industrial undertakings. This modus operandi has been adopted by certain assessees since inception of the industrial undertakings, and in some cases it was adopted after the decision of Mahindra Mills case of the Honorable Supreme Court. Stop.